Good morning. It's the appointed time, and we have a quorum. I call to order the meeting of the Bills Committee. At the end of the last meeting, I said that if members did not have other questions about the policy matters of the bill, we will commence the clause-by-clause examination. Let's first invite representatives of the administration to come inside the conference room. If members do wish to follow up on certain issues, I'll let the relevant members ask questions first, and then we'll go into clause-by-clause examination. Mr. Chan Siu-hong. Well, actually, let's wait until representatives of the administration to come inside the conference room first. I would like to now welcome Undersecretary and his team to the meeting. All right, Mr. Chan Siu-hong, 5 minutes. Thank you, Chair. I'll be brief. As said by the chairman, we are to go into clause-by-clause examination, but we have received submissions at the last meeting. A verbal reply was given at the last meeting, but I suppose the administration will provide a detailed written reply in due course, because we do want to respond to the concerns of members of the public and deputations, and if necessary, clarifications can be made by the administration on certain issues. So I want to know if it is the case that the administration will indeed provide a detailed written reply to the submissions. Thank you. I believe the administration, seeing that the last meeting was only held not long ago, will provide a written reply to written submissions or oral submissions in due course. Well, I guess depending on the situation, members may also follow up on the submissions during clause-by-clause examination. I will also allow certain general questions if circumstances warrant so, and the administration can then give a reply on that. Undersecretary, anything to add? Well, thank you, Chair. We are indeed preparing the written reply, and we will provide it when it is ready. We are also more than willing to respond to questions or concerns raised during the clause-by-clause examination. Thank you. All right. Thank you. If members have no other questions, we will commence the clause-by-clause examination of the bill. As I said last time, we can refer to the blue bill and the marked-up copy. That is LC paper number CB brackets 2121/2024 brackets 01. Our usual practice is that the Bills Committee would first look at the Chinese version of the bill, and at the same time, the legal advisor would deal with the English version of the bill. During scrutiny of the bill, as you may know, legal advisor has raised some questions and the administration has given a response. And when we get to those clauses, the legal advisor can perhaps repeat the relevant points then, and members may ask questions. I'll now invite the administration to start the clause-by-clause examination. Thank you. Who will be giving us the scrutiny? Who will be leading us in the scrutiny? I'll let the assistant director do that. Mr. Alfred Lee, thank you. Let me first say that we have 43 clauses, and it will amend the Building Management Ordinance, Chapter 344. As said at the very first meeting, we have covered some procurement of supplies, goods, or services. We have also provided for a mechanism under which natural persons are to be authorized by corporate flat owners, and with certain arrangements regarding criminalization of failure to keep certain documents. The ordinance was promulgated in 1972. It has been quite some time, so we also want to make some related and miscellaneous amendments to the ordinance. Regarding the short title and the commencement, well, actually, for the long title, as I said, it will impose certain requirements in relation to the procurement of supplies, goods, or services. It will also provide for a mechanism under which natural persons authorized by corporate flat owners may act for the latter at general meetings of owners' corporations. Certain requirements will also be imposed or adjusted in relation to financial statements and other accounting documents. Also, it will criminalize the failure to keep certain documents concerning building management. Regarding the short title and the commencement, as set out in Clause 1, the ordinance comes into operation on the expiry of 12 months after the day on which it is published in the Gazette. There's Clause 2, it will amend Building Management Ordinance. Clause 3 would amend Section 2. There are several subclauses to this. 1, there are some definitions that will be provided, and we would amend Section 2 and add new sections 2C, 2D, and 2E to provide for the meaning of certain expressions, including Type 1 high-value procurement, Type 2 high-value procurement, and large-scale maintenance procurement. And we have also added some terms regarding the relevant large-scale maintenance procurement. The participants and the responsible person would have to make declarations regarding connections and interests. So we have defined connection by referring to other ordinances. We have also set out the voting in person threshold and authorized natural persons definitions. Depending on the transitional provisions, we have also set out the initiation date and initiation decision. Initiation date is the date on which the initiation decision is made for at a meeting. Also, it was mentioned there would be a specified form for the form specified under sections 8(6), 28M, and 34EA. And in section 34D, we already have some definitions of the terms, but in order to have better structure, we have now moved such definitions into section 2. We also want to better certain drafting of the terms such as the Management Committee resolution, as well as the certified minutes, functions, and so on. And in E, we have put in the definition of validly. That is in relation to the sending of a document in electronic form. The specific definition is in section 2E brackets 2. So that is clause 3. On clause 4. Well, can you talk about interpretations? There are some concerns to be raised by members. Perhaps you can address such concerns after members have spoken. Thank you. Mr. Leighton Kwok. Well, I think there are quite a lot of definitions in section 2. If the administration is so brief as they did just now, it would be confusing. I want them to talk about each and every definition. Otherwise, we may miss certain important information. Well, I myself did want to raise this issue before. Perhaps we can have Mr. Lee talk about each and every term. Okay? Mr. Chan Soo-hong. Well, when the administration was briefing us on the first few clauses, I thought, as Mr. Leighton Kwok said, we should have better definitions, and that's why we should be more clear with the interpretation given. And Chair, during clause-by-clause examination, we would have mocked up copies. So I would suggest the administration to refer not only to the blue bill, but also to the mocked up copy by page. Because I myself wrote my questions in the mocked up copy as well. If I have to cross-reference, it may be somewhat inconvenient. So I hope that the administration can examine the clauses making use of the mocked up copies. Thank you, Ms. Doreen Kong. Thank you, Chair. I would agree with what Mr. Leighton Kwok said. As I read the bill earlier, most of my questions are indeed on the interpretation of the terms. Well, that's what we were thinking. So, Mr. Lee started with a summary. I think we are all of the same view. Perhaps we'll have Mr. Lee start again. All right, thank you, Chair. Let's refer back to clause 3 on brackets 1. Section 2, it has been renumbered to section 2 brackets 1. For brackets 2, in the English text, the definition of tribunal, the full stop has been repealed and a semicolon has been used to replace it. Mr. Lee? Well, perhaps we can make use of the marked up copy. So we'll refer to page 1 of the marked up copy, and then you can talk about page 2 and page 3 of the markup copy and so on. Thank you. Well, on page 1 of the markup copy, there is not much change involved. And then on page 3 and page 4 of the marked up copy, regarding exempt estate, in the Chinese text, we have repealed the full stop again and replaced it with semicolon. And after that, we have added a definition because that is new.
Mr. Kong? Well, excuse me, I didn't mean to press the button. We are talking about exam estate. I'd like to know more about it. Do we have this definition right now? Well, we don't have any exam estate. Let's continue. Let us continue. It's about the mandatory DMC terms. Section 34D definitions have been moved forward by virtue of Section 34E. DMC manager likewise. It refers to the person who is specified in the deed of the mutual covenant to manage the building. Mr. Kong. Thank you, Chairman. I'd like to ask about the term DMC manager. What about those employed on contract terms? It's DMC manager right now. That is those employed by way of DMC. Many housing estates have management contracts, even including single block buildings. I know there is another definition about manager, but sometimes those employed under a management contract will also be a DMC manager, especially when it comes to the building without any DMC or any OC. What about Red Hill Peninsula? Do those under management agreement, should they be covered as well? Can you speak up, please? Let us turn to the definition of manager. That is page 7 in the marked up copy. There are two meanings. One, the DMC manager or any other person who, for the time being, is for the purposes of the deed of mutual covenant managing the building. The person being responsible for the management of the building falls into the definition of a manager. Well, I don't quite agree. It's a legal concept. In the context of a building where there is an OC, the OC is the DMC manager. In the absence of an OC, property management companies, PMCs, are the DMC managers. Such being the case, those employed under management contracts should also be the DMC managers. Legally, major managers and other types of managers are different concepts. In the absence of an OC, major managers are the PMC, property management companies. Mr. Alfred Lee. Under Section 34D, the definitions of manager and DMC managers are already there. There are many definitions, and we'd like to move them forward. This part of the bill focuses on provisions in relation to DMC. We will also touch upon manager or DMC manager. That's the reason why we move forward the definitions of manager and the DMC manager. As I mentioned, DMC managers refer to the manager specified in the contract. In the case of manager, right here, it refers to the DMC manager or any other person who for the time being is for the purposes of the DMC managing the building. In any event, the definitions have already been covered under manager. I have no follow-up. Thank you, Chairman. Mr. Alfred Lee, please continue. Let's go back to page 5 of the marked-up copy. Regarding hard copy form, that is page 6 of the English marked-up copy. It specifies the ways in which the hard copy form can be submitted. We will introduce further in section 2E(1)(b). When it comes to validity, we will touch upon this in section 2E(2). Validity is on page 8 of the English marked-up copy. Regarding corporate flat owner, that is page 5 of the marked-up copy. Body corporate will be authorized to vote in person. So a corporate flat owner means an owner that is a body corporate. That includes land tribunal as well. Court includes land tribunals as well. Do corporate flat owners include mortgagee in person? Well, mortgagee in possession. Under the definition of a flat owner, actually mortgagees in possession are already included. I'd like to be clear. As the definition of flat owner includes a person who for the time being appears from the records of the land registry to be the owner of an undivided share in land on which there is a building and a registered mortgagee in possession of such share. Let us go back to the definition of court. Court also includes the tribunal. Next, corporate resolution. It is only a textual amendment to make it clearer. It means a resolution of the owners passed at a general meeting of the corporation convened and conducted in accordance with Schedule 3. Mr. Rincon, well, excuse me, Chairman, I have more questions. Regarding corporate resolution, it means a resolution of the owners passed at a general meeting of the corporation convened and conducted in accordance with Schedule 3. What about those convened and conducted in accordance with the DMC? Is it also a corporate resolution? It is not conducted in accordance with Schedule 3. Well, members, if you have any questions, as Mr. Alfred Lee is walking us through the marked-up copy, you can press a button and the Secretariat will remind me to allow members to ask questions. Just feel free to ask questions. The administration will reply to members. Mr. Alfred Lee, please. For owners meeting, you can refer to owner's resolution. That is page 5 of the English marked-up copy. It means a resolution of the owners passed at a general meeting. Well, I understand this point, but let me explain the reason why I asked this question. It is specified in the definition a general meeting of the corporation convened and conducted in accordance with Schedule 3, but Schedule 3 differs from Schedule 7. It is not a mandatory provision. in case of any difference, Schedule 2 and Schedule 3 will prevail. If corporate resolution, for example, you have a lot of meeting minutes, if you are just going to write in accordance with Schedule 2 or 3, but when it is not a mandatory provision, why don't you just write it down more clearly that is in accordance with Schedule 3 or DMC? I'd like the DOJ to give me a hand. I was thinking why we couldn't write down a resolution of the owners passed at a general meeting of the corporation convened and conducted in accordance with Schedule 3 or DMC. Mr. Lee, there are two resolutions. One, there's a corporation, as Mr. Ring Kong said, it is a meeting convened and conducted in accordance with Schedule 3. That is what we have in the definition. If the meeting is convened in accordance with the DMC, that will be the definition of owner's resolution. That is on page 7 of the English marked up copy. Owner's resolution means a resolution of the owners passed by a majority of the votes of the owners voting either personally or by proxy at a meeting of owners convened and conducted in accordance with the DMC. While owner's resolution means a resolution passed in the absence of an OC. Every building has a DMC. Why can't you just write down in accordance with Schedule 3 or DMC? Well, no problem. I don't mean to stand in the way. Can the administration think it through based on what I know? A corporate resolution means the existence of an OC, whereas for owner's resolution it means the context without an OC. My question is, why can't we add in accordance with Schedule 3 or DMC? Why can't we add or DMC? Many buildings convene meetings in accordance with the DMC. We are not convening meetings in accordance with Schedule 3. Instead, we do so in accordance with the DMC, but the Schedule 3 will prevail in case of any disputes. Director, let me try to explain. In interpretations, what I mean in the subsequent parts, there are corporate resolutions, there are also owner's resolution, and we will have to refer to the interpretations in this section. If I'd like to refer to the resolution of Schedule 3, there are many words. It's not clear. The texts are quite verbose. So we add the definition corporate resolution. In subsequent sections, when we refer to meetings convened in accordance with Schedule 3, it will refer to corporate resolution. Whereas Mr. Ring Kong mentioned meeting convened and conducted in accordance with the DMC. The texts in the legislation are very verbose, so we'd like to take this opportunity to add owner's resolution. We want to add this definition, so when we have to describe this scenario, we can use owner's resolution and we can refer to this interpretation. When we go to clause-by-clause examination in a moment, we will touch upon owner's resolution, and we will also come across corporate resolution or owner's resolution or corporate resolution. That is what we think.
Mr. Lee, thank you. We have defined corporation resolution and owners resolution separately because, as the director said, there are different uses. For example, if we look at 189 of the markup copy, we could see type 2 procurement there, type 2 high value procurement, and in bracket C. For a corporation, we would require a corporation resolution. If there is no corporation, we would require an owner's resolution. So this decision to separate the two is intentional because we would need different definitions in different scenarios. Thank you. Mr. Andrew Lam. And in fact, I myself, when I read the bill, it took me quite a while to refer back and forth just to get a better understanding of the bill. Ms. Doreen Kong is very proficient in legal knowledge, so she could tell right away something may be wrong. I would say that the administration can perhaps set out a list of the different scenarios in which different definitions would be used. In fact, I myself did identify potential overlap in certain situations. So if the administration can provide a list of possible scenarios for easy reference by the public, it would definitely facilitate public understanding. Well, thank you, Chair. I think Mr. Lam can be a bit more specific as to what he would want to see in that particular document. Well, I would say that, as you said, there are different definitions for corporation resolution and owner's resolution, and that there are managers and DMC managers. There are also responsible persons. They, I believe, would have different uses in the remaining clauses of the bill. But then if we are only looking at the interpretation, if one is not familiar with the bill, people may get confused about the different functions of these definitions. So is it possible for the administration to have a list setting out the different scenarios in which different definitions will be used and the responsibilities of the relevant parties? I think potentially the list could be quite useful. I should have raised this at the last meeting. I do apologize, Chair. But it was only when I was flipping through the bill that I found the references to be quite complex. I wrote way too many notes in the bill. There are simply that many references. I myself have been a couple of bills committees, so if it is that difficult for me, I can't imagine for the members of the public to understand this easily. So I don't mind what you're doing at the moment, but it does cause a bit of confusion depending on the level of knowledge of different groups. I think Mr. Lam did make a good point in order to facilitate easy follow-up, because depending on the circumstances, people may not be sure of the different responsibilities in different sections. So I think since more than one member has raised this issue, saying there is difficulty in following the provisions, I think that would be desirable. And as members said, if members have difficulties themselves, it would only be even harder for other people, such as members of the public. Director, well, we are making amendments in 3 major areas, such as the statements and the relevant criminalization of not keeping certain documents and providing for requirements for procurement. I think perhaps we can give a summary of each area, and we can mark the sections that have been amended. Well, I think all we want is facilitation of understanding. Dr. Lo-Wai Kwok, thank you. Well, I would say that interpretation serves as a part where references can be made to the definitions. So I think we do not really have to dwell on the interpretations at the moment, because it will take forever if we dwell on these. I think we can get to the clause, and if we have certain questions about the definitions concerned, we can raise issues then. I do agree with what Mr. Doreen Kong said, but I think we can take a different approach. Thank you, Ms. Doreen Kong. Thank you, Chair. I do understand in which settings the different definitions of corporation resolution and owner's resolution are to be used. But as said by other members and the chairman, the law would have to be read by members of the public. So I think it should be made clear that corporation resolution would be applicable when there is no incorporated owners, and owners resolution the otherwise. And as Mr. Chan Hock Fong said, we won't rely only on Schedules 2 and 3 to convene and conduct a general meeting. One must have a DMC before you convene a meeting. So can you go back and think about that, and you can ask the DOJ about this for confirmation? Thank you. Well, I think Ms. Doreen Kong has a problem with the wording of the definition. Well, due to time constraints, I think we can take note of Ms. Doreen Kong's view and reconsider that after the meeting. All right, the next definition is with specified forms. That is the specified forms for natural persons taking part in meetings, and in another specified form in Schedule 6B. It would be the specified form in Section 28M. As for the one in Schedule 7, it is the form specified in Section 34EA for making declarations. The next definition is responsible person. Excuse me. Mr. Chen Xiu-hong, do you wish to ask something about responsible person? Okay, please proceed. Responsible person in relation to the procurement of any supplies, goods, or services for a building means the manager of the building or a person who is accustomed or obliged to act in accordance with the directions or instructions of the manager. And I would like to clarify that this does not include any management committee members or secretary. And I want to also talk about for the specified forms for management committees, they would have a different mechanism in place. As for managers, they have another set of mechanism. That's why we have made a separate definition for responsible person. Thank you, Mr. Chen Xiu-hong. That is exactly what I wanted to ask, Chair. So, responsible person, one would have to make a declaration for procurement, but for managers, they would also have to make a declaration. So I think it is in Section 9 brackets 2 that it says so. So if a management committee member is to procure something, they should follow the declaration mechanism for management committees. Is that correct? That's why you have made separate definitions for the two. Mr. Lee? Yes, Mr. Chan's understanding is indeed correct. Ms. Doreen Kong, I want to ask about A2. Because this definition is new, I do want to ask questions about this. For A2, it says a person who is accustomed or obliged to act in accordance with the directions or instructions of the manager made to the person directly or indirectly. What do you mean by accustomed or obliged? When there are instructions or directions, wouldn't that be enough? Well, thank you, Mr. Lee. For example, there is an agreement between the incorporated owners and a management company. A second scenario would be an employee of a property management company that would be acting in accordance with the supervisors of the management companies, perhaps. There are different high levels in the hierarchy of the management company. So it may not be the company that would be giving directions to the employee. That's why we want to have a scenario that would catch the relevant situation. Well, usually I would say that in law they would make use of the term agent. I haven't seen such wording that is a person who is accustomed or obliged to act before. Why can't you just say that an employee that has directions or instructions of the manager? Otherwise, it can be anyone, really. The wording that you have here is not very legal. It is very hard to understand for a legal professional. So I am not objecting to the definition per se. I just want to ask what your justifications are for wording the provision in that manner. Thank you.
Anything to add, Mr. Lee? Can I ask the DOJ to further explain it? Thank you, member. Regarding the words accustomed or obliged, well, I can supplement in a moment. Perhaps back then there weren't any directions, but then by conduct there's a person who has been doing so. So the implication is that that person has already shouldered the responsibility. This is a word describing the situation. I can supplement what other pieces of legislation are using this word, but indeed this word is being used in other pieces of legislation. Ms. Doreen Kong has been asking questions in relation to the understanding of the word, whether using some words is appropriate, and so on. Of course, making suggestions is good, and the administration also said that they would look into it to identify any room for improvement. The administration can supplement about this. Next, Mr. Andrew Lam. Thank you, Chairman. Riding on what Ms. Doreen Kong said just now, 義務 in Chinese is obliged in the English version, but I think the word 義務 in Chinese covers a wider scope. It could be accountant or lawyer pro bono. I'm worried that it would also cover the employees of a company. When it comes to direct or indirect directions or instructions, that would be very wide. Originally, you mean as long as a person has taken part in the decision-making process, then that person is also covered. If my understanding is correct, well, I can use this understanding throughout scrutinizing the bill. But if the scope is such wide, like what Ms. Doreen Kong said, you need to clearly define it. Director, Mr. Andrew Lam is correct. In the English version, I'd like to explain.
Directions 咁樣，即係其實係講緊 accustomed 同埋 or oblige， 就係頭先
So just now, that is the situations covered by the DOJ. I mean, explained by the DOJ. In our Chinese explanations, we write down 關於或有義務, that is accustomed or obliged in English. Next, Mr. Lai Tong Kwok. Thank you, Chairman. It's clearer right now. I'm not sure whether you would like to use the Chinese or English version. Lexical meaning in Chinese and in English are very different. Obliged does not mean 義務 in Chinese. It means something that must be done. 義務 in Chinese, in contrast, means that something can be done or somebody does not have to do it. 義務, it's very different. So if the administration would like to use the English version, you will need to come up with yet another word in the Chinese version so that the two are comparable. They are the same. The word accustom means that we need to base on some facts. When you need to look for somebody to be responsible for it, you will have to do a lot of research before you can decide whether it is accustomed or not. This will give rise to a lot of problems. This definition covers A and B. That is whether the person is the manager of the building or a person who is accustomed or obliged to act. In actual operation, is there any overlapping of these two capacities? Can a person be both a treasury and a secretary? Can you rule out this possibility? If you can't, using the word "and," that is cup in Chinese, do you think you are limiting your scope? You are confining it. How can you explain clearly to the management committees? This is quite a technical issue, but it will have a far-reaching effect. We don't know what problems will ensue in the future, so I'd like the administration to give this word some thought. If so, what administrative means will you have to employ to allow others to know clearly your legal requirements? Well, I think the director and the undersecretary can give it some thought. Now that we're working on interpretations, we need to know the intent. So the Chinese and English versions should match one another. I understand in the examination of the clause-by-clause process, many words are covered, but in the context of interpretations, we do need to standardize the meaning of some words. That is whether we can achieve the intent we want to achieve. So, which official could respond to Mr. Lai? Just now, Mr. Chen also mentioned, in relation to responsible person, management committee, treasury, there are two mechanisms for them to declare interest. For example, we have the mechanism for responsible person and another mechanism for treasury and secretary. Is it possible that someone may be both the treasury and the secretary of the management committee? Yes, there are such scenarios. Maybe the flat owner can also act as the secretary of the MC. Well, I mean the treasurer of the MC. If one is the responsible person, according to the definition, one has the obligation to declare interest. As the secretary of the MC, he or she also has the responsibility to declare interest. Thank you, Chairman. Dr. Low? Dr. Low? Am I coming through? Thank you, Chairman. Well, I think the Chinese text is a little bit weird. If you cross out accustomed or obliged to, it will become a person who acts in accordance with the directions or instructions of the manager in connection with the procurement and so on. If a responsible person is the manager of the building, or when he or she authorizes another person to be the manager of the building, maybe that is the first time, so that is not accustomed. And it's not the case whether it's obliged or not. Well, the English version is not that weird, but that it is weird with the Chinese version. And next, does not include a member, secretary, or treasurer of the management committee in respect of the building. Does it give the impression that a member, secretary, or treasurer of the MC cannot take part in the procurement process? From the Chinese text, you give the impression that these people are excluded. They simply can't take part in the procurement process. Let us hear from Ms. Eunice Yong. The administration will reply later on. Regarding accustomed or obliged to, if there are provisions containing these words, well, I can find such legislation. In the SFC ordinance, there are such words, but then they are used to describe other matters. Let me go back to the ordinance, the SFC ordinance. That is associate. That is a person acting in accordance with the directions or instructions of the other person. But then we are talking about the subject instead of an associate. So that is indeed not the subject, rather it is the associate. I can only find the words accustomed or obliged to in the SFC ordinance. That is the Securities and Futures Ordinance. Instead of putting the definition from the Securities and Futures Ordinance under the Building Management Ordinance. Thank you. We have heard members about the discrepancy between the Chinese and the English texts when it comes to the words accustomed or obliged to. Mr. Chen Xiu-hong, members are concerned about the words accustomed or obliged to. If the Chinese version does not match the English one, will it cause confusion? I've taken part in quite a lot of bills committee, and I came across such problems as well. Oblige in its English sense is clear, but when translated into the Chinese version, it's quite different. Should we adopt the approach of literal translation? Do we need to look for another Chinese equivalent? For the definition targeting responsible person, that is a person responsible for procurement. The definition is actually quite good, but then will it be too wide in scope? For any person who needs to declare in procurement of the value more than $200,000, the amount is not a small one. But if the manager of the building is responsible for the procurement, definitely that person will not act alone. Probably a team or other staff members will also take part in the procurement exercise. Probably there are other staff members who are instructed or directed to do so. As I understand, there are internal guidelines within a company. That is to say, a person is accountable to his or her higher up when one makes a decision or when one makes a procurement decision. If all these cases require declaration, that will be quite cumbersome, despite the fact that it is well intended. Whatever the procurement is, one still needs to declare it. Well, I'd like to ask the administration to think it through. Will the net be too wide? Thank you.
Well, I think it is very important to talk about the intent. Will the administration please elaborate on that? Thank you, Chair. We do hear what the member said and about declarations. And in fact, several members mentioned the problem about the difference in the Chinese and English text of the interpretation. We'll definitely study that closely afterwards. We'll make sure there is no misunderstanding. Please also think about the part for managers and responsible persons. Is it the case that you do wish to have that wide of a scope? We did hear what the member said. We will take note of it and we'll take that into consideration. Thank you. Mr. Andrew Lam, I've already spoken. Thank you, Chair. All right, thank you, Ms. Doreen Kong. When we talk about disclosures in Section 81, who will be covered? Is it officer, agent, and employee, all of them? I just want them to really think about that, Section 81, while we're on this point. Thank you. Of Chapter 621. Thank you. I now want to talk about the definition of first tender acceptance meeting on page 6 of the marked up copy. In relation to any large-scale maintenance procurement, if there is a corporation, it would refer to the first general meeting of the corporation convened under Schedule 3. If there is no corporation, it would mean the first meeting of owners convened under the DMC. For MC participants, they would need to make declarations of additional interests if necessary. That's why we have a specific definition for first tender acceptance meeting. Ms. Doreen Kong. Thank you, Chair. I want to ask about A of the definition. I would say what I said before, the meeting of the corporation should say convened under Schedule 3 or the DMC. I'm also looking in the English text. At the very last part, it says at which the question whether a tender submitted for the procurement is to be accepted or not is considered. If it takes several meetings to talk about the issue of procurement, do you still refer only to the first meeting? Mr. Lee? Thank you. Yes, we are only referring to the first meeting, as it says so in the definition, in the term that is first tender acceptance meeting. Thank you. As I talked about the definitions of function and hard copy form the participant earlier, so I will not go into details about that. Regarding initiation date, in relation to the procurement of any supplies, goods, or services, if there is a corporation, it would refer to either 1. The date on which the initiation decision is made for the procurement by a management committee resolution, or the date on which the initiation decision is made for the procurement by a corporation resolution, whichever is the earlier. Or if there is no corporation, it would be the date on which the initiation decision is made for the procurement by an owner's resolution or otherwise in accordance with the DMC. As said, for type 2 high-value procurement, we would have to refer to the value of procurement, whether it would exceed or is likely to exceed 20% of the reference amount. For example, the average annual expenditure in the last 3 financial years. That's why we have set out the initiation dates definition in the interpretation. Regarding initiation decision, in relation to the procurement of any supplies, goods, or services, means the decision that the procurement is to be conducted and includes the decision that potential suppliers are to be approached for the procurement. For type 1 high-value procurement, we would have the detailed definition in section 2C. It would be the same for type 2 high-value procurement. Next, it would be owner's resolution. It would mean a resolution of the owners passed by a majority of the votes of the owners voting either personally or by proxy at a meeting of owners convened and conducted in accordance with DMC. The next definition is that of certified minutes. There are 2 scenarios. One in relation to a meeting of a management committee, any minutes of the proceedings at the meeting that are certified in accordance with Schedule 2, or in relation to a general meeting of a corporation, any minutes of the proceedings at the meeting that are certified in accordance with Schedule 3. Mr. Chen Su-hong, thank you. I actually wanted to ask about initiation date and initiation decision. By initiation, do you mean when the contract was signed or when the procurement is initiated? But it is often the case that a certain individual or a member will be authorized by the corporation to sign the agreement with a contractor. If you say here specifically with the initiation decision, will you account for the scenario where another agent would be authorized? So, because as I know, it is often the case that owners' corporations will not specify the date on which such acts are carried out. Thank you. Mr. Lee? Well, I think what we have right now is not about the signing of agreements. Say for type 2 high-value procurement, we're talking about the value of procurement which exceeds or is likely to exceed 20% of the average annual expenditure in the last 3 financial years, for example. So it would have to start on a particular date. That is when the 3 financial years would start. For type 2, of course, they would have to make declarations of interests. They would also have to invite tenders. The circumstances would depend on the actual circumstances under which the corporation is going to act. Okay, so I think what you meant was when a decision was made to initiate such process at a meeting, and the 3 financial years would date back 3 years from then. The procurement process would not necessarily start then. That is, it is just that a decision was made. But sometimes there would be a gap in between then and the actual procurement process would begin. How would you account for that? Because I can see that there may be some confusion. Mr. Lee, thank you. I think when a corporation or owners are about to procure something, they would have a budget in mind. Depending on what the actual entity or supplies goods or services to be procured, there will be different treatment. If tenders are to be invited, if it is not right for the corporation or owners, that process may have to start again. So what I'm saying is that the initiation date is just a first step to many other steps that would come after that. Thank you. Thank you, Chair. I understand where the administration is coming from. They want to set a date for which, when a decision is made, one can date back from that date and see how they are going to comply with their requirements. But then I want to ask, what would a decision entail? Would that entail getting quotations? Or is it otherwise? Or other processes? So is it the case that an actual decision has to be made that would constitute a decision? Or is it the case that it would start with getting quotations or asking about prices? Thank you. Well, I would say that for initiation decision, one would be clear about what that entails. It would mean the decision that the procurement is to be conducted and includes the decision that potential suppliers are to be approached for the procurement. Ms. Doreen Kong, I want to ask about certified minutes. The part in A would apply to corporations. And I think B would apply also to corporations. What about for those without owners corporations? Well, is it Tony that will speak on this? Oh, Mr. Lee, thank you. We are just talking about specifically different scenarios that would have minutes certified in accordance with Schedule 2 or Schedule 3, respectively. Ms. Doreen Kong, that's it from me. I just want to clarify that this would not be applicable to those that do not have corporations. That is those without corporations do not have to submit certified minutes, correct? Mr. Lee, it would depend on the DMC. Because right now the BMO does not set out in Schedule 7 the mandatory DMC terms that they would have to provide certified minutes. If it says so otherwise in the DMC, then they would have to provide certified minutes. Thank you.
Mr. Lai Tong-kwok. In the absence of, for buildings without OC, if the existing legislation does not have the requirements, how do you plug the loophole? There are loopholes. Mr. Lee. Thank you, Chairman. The owners have the right to ask the OC for the certified minutes. So in the legislation, we have set out in Schedule 2 any minutes of the proceedings at a meeting that are certified in accordance with Schedule 2, that is in relation to a meeting of a management committee, whereas for B, that is in relation to a general meeting of a corporation. Under the Building Management Ordinance, it does not regulate the operation of buildings without OC. That is exactly where the problem lies. There are many 3 new buildings. Not all buildings have OCs. They also need to carry out repairs. I understand DMC was entered into a couple of decades ago, so the administration needs to work to plug these loopholes. You know that there are such loopholes, so why don't you plug the loopholes? There are obvious loopholes, but you don't plug them. That is my concern. Mr. Lee, in Schedules 2 and 3, they do not actually work to address large-scale maintenance. We actually have EM Pass. Through NGOs and PMC, we help 3 new buildings to set up OC. Then they can work according to the mechanism, especially in relation to large-scale maintenance. The buildings department also contacts us. Then we will partner with the NGOs in order to set up OC for the 3 new buildings. Then the provisions under Cap 344 will apply. But we are now talking about procedures not relevant to large-scale maintenance. It's about drafting. That is to obtain certified minutes, and this has nothing to do with large-scale maintenance. In the definition, you write down minutes of the proceedings. That is in Chinese 過程記錄. You added the word proceedings instead of just the word minutes. What is the reason that you need to add the word proceedings in the English version? I'd like to invite the DOJ to give you more information. Who will answer the question? Mr. Ng. Thank you, member, for your question. That's the way it is expressed in existing legislation. We have no intention to change it. That is why we use any minutes of the proceedings. Usually, minutes mean minutes of meeting, but then you have now added the word proceedings. There is always a reason why you do so. I'd like to know what it refers to. Mr. Lee or Mr. Ng? Maybe Mr. Ng, do you have anything to add? Thank you, member, for your question. It refers to the conduct of the meeting. That is, throughout the process, there's a record of the meetings. In usual language, it refers to the conduct of a meeting. It does not have any special meaning to it. Mr. Lee, anything to add? No, not from me. Thank you, Chairman. Mr. Lai asks about the actual purpose of this word. What do you make of it? Under Secretary? We've heard Mr. Lai. We'll go back and think about it. Afterwards, we'll let members know. Next, Dr. Lo Wai Kwok. Thank you, Chairman. On interpretation, we've had much discussion, and I need to restate my position. The definitions under the section interpretation have a lot of reference to the provisions later on. For example, we need to define the first meeting. We also need to explain what initiation means. At this stage, questions about definitions are indeed cumbersome. So when you have recorded our questions, when you find the definition sufficient, or when you think that more adjustments are needed, you can do so. You mentioned a couple of scenarios, that is procurement, maintenance, procedures, and so on. You've given us, well, I mean, it would be better if you gave us a flow chart. What do you want to do under a certain scenario? That will give us a big picture. It will be easier for us to discuss the matter. View noted. We'll work on it. Thank you. In a previous Bills Committee, I also proposed this method, and members found it useful, as the flowchart would help us understand the situation better. Professor Priscilla Leung. Thank you, Chairman. I'd like to ask something general. We are not talking about large-scale maintenance, as the administration said. Can you tell us why? We are not talking about large-scale maintenance, but what we are discussing includes large-scale maintenance. Is that what you mean? I'd like to record it. Chinese and English translation. Well, that is the legacy of the bilingual law drafting committee. There were heated discussions, and we decided on literal translation. So all of us who read law will turn to the English version in order to understand the essence of the legislation. We don't understand the Chinese version, actually. We go to the English version. The DOJ should work to improve the situation. However hard it is to read the Chinese text of Cat 344, flat owners will always like to go to the Chinese version. They won't want to splash out on engaging a lawyer to explain the English version. Every time I sit on a Bills Committee, that's always a problem we have. When we do literal translation, the grammar does not work. It doesn't make sense, and that is the legacy of the Committee on Bilingual Legal System. The administration said that they would like to encourage NGOs to help buildings without OC to set up OCs. For example, for old tenement buildings to set up OC. Actually, the help from NGOs does not suffice. We do need the administration, we do need the bureau. You need to give a hand. If you are not going to do anything at all, the resources are actually going to waste. After all, many people are afraid of the responsibilities or accountability, so they are, They do not want to take part in the OCs. OCs shoulder great responsibility, and this problem hasn't been solved. It would be better if there is a government official who calls the shots eventually, and I'd like to know why large-scale maintenance isn't covered. Regarding this point, I'd like to tell Professor Priscilla Leung we were actually discussing certified minutes. My colleague meant that it is textual amendment instead of large-scale maintenance. Speaker off mic. Well, I mean both large-scale maintenance and those that are not large-scale maintenance are also covered. Mr. Ring Kong, I'll be quick. I agree with Mr. Lai Tong Kwok. Why do certified minutes only cover corporation? Well, in Kowloon, I help many large housing estates that do not have OCs. Not just 3 new buildings. Actually, over half of the buildings in Hong Kong do not have OCs. So where possible, when we can plug the loopholes, we should do so. For large housing estates, PMCs do not provide minutes even when they are asked. So I hope the administration will plug the loophole in the future. Any response? Any response to Mr. Ring Kong's remark? We've heard Mr. Ring Kong. After all, the aim of CAP 344 is to help with the operation of the buildings with OCs. So, as we were saying, certified minutes are actually about the buildings with OCs. In Schedule 7, mandatory DMC terms have gone through public consultation. They affect all buildings. It's not the administration that can unilaterally make decision. So in Schedule 7, we don't touch on buildings without OC in relation to the record of the meeting, that is the minutes. But of course, we've heard members. Mr. Kisan Yang. Thank you, Chairman. I'd like to follow up on Mr. Ring Kong's question. This building management ordinance is about the management of building. Even in Kowloon, there are many buildings without OCs. PMCs are responsible for managing these buildings. In case of any disputes, as Mr. Ring Kong said, the PMCs do not give you the meeting minutes. When we have a piece of legislation, and I'm not going to delve into this ordinance, before the legislative exercise, you should have given it some thought. You do need to give it some thought. Don't just focus on the management of buildings with OCs. That is not quite correct. The ordinance itself is called Building Management Ordinance. It's not right to just focus on buildings with OCs. As I understand, there are statutes or provisions regulating the record of meetings or the requirements that owners need to comply with while they are requesting meeting minutes. That is a concern of member. Undersecretary, please. We've heard members, Secretary and me myself. In our future direction, how should we proceed? What is our vision? The building management responsibility is that of owners. Meanwhile, we use this ordinance to help monitor the management of building, especially under Cap 344, Schedule 7, buildings without OCs are included. Just now, the chairman mentioned through Cap 626, that is Property Management Ordinance. There is regulation or guidance given to PMCs or managers. That is Cap 626 Property Management Services Ordinance. We'll take on board members' views and we'll continue to talk to stakeholders. We'll keep close liaison with them in order to improve the situation.
Well, in order to facilitate members' understanding, especially when Mr. Yang asked about the arrangements for minutes to be kept and when requested what to do, perhaps the administration can provide more information on this. Professor Priscilla Leung, I myself worked as a district councillor for 13 years, and one of the largest housing estates in Hong Kong, Whampoa Garden, does not have an OC. Whenever we ask about the expenditures and we ask for the relevant information from the property management company, disputes arose and there were protests. This is a problem that persisted from 1985, where there are many buildings that have the same issue. I myself raised at a previous meeting that we should deal with this. Back then, you have made legislative amendments, and it is the only way that we can implement change, apparently. I think the administration does not understand that we really have to do something through these legislative amendments to tackle these persistent issues. I do understand that the Undersecretary said there may be further legislative amendments, but if we are only making minor amendments on each occasion, it may not be desirable, and I hope that the administration know that there is this issue. Chapter 344 would be applicable to all buildings, and we actually make use of Chapter 344 to tackle the problems with Whampoa Garden then. So it is very important. Thank you. Well, I think for this legislative amendments in particular, we're focusing on building management by corporations. Thank you. I now want to talk about the definition of manager in relation to a building means the DMC manager. This is an existing definition, but as I said earlier, it has been moved forward to Section 2. The next definition is electronic form, the details of which are set out in Section 2E brackets 1 brackets A. The next would be management committee resolution. It is an amendment. It means a resolution of the management committee passed at a meeting of the management committee convened and conducted in accordance with Schedule 2. The next definition is voting in person threshold. This relates to large-scale maintenance procurement. It says in relation to the passing of a resolution of the owners at a meeting means a minimum number of the owners who must have cast a vote on the relevant proposed resolution personally, but not by proxy at the meeting in order that a decision may be made by the resolution. It is a new definition that has been included to impose the requirements in relation to large-scale procurement. Mr. Yang Wing-kit, I want to ask, what would voting personally mean? Some, when they are voting, they can just take their option of their choice and they will hand the vote over to other people, and other people would put it into, say, a box for them. So I want to ask what specifically voting personally would mean. Mr. Lee, thank you. We do not have any restrictions in this regard. We are just asking that owners attend the meeting personally and vote. So the vote may have been made by the owner themselves, but if someone is to put the vote in the box for them, that would be acceptable. Thank you, Mr. Yang Wing-kit. Well, for certain cases, there are people who would vote at the very end, and there are certain instances where people will have to vote one by one going to the box, so to speak. So what would voting personally entail? I think the focus should be on who would be selecting the option of choice on the vote, not about who is going to put the vote in the box. Thank you. Mr. Andrew Lam. Thank you. I understand the concept of attending the meeting personally, and it says so in the English text, not by proxy. In Chinese, it is different. It may be confusing because it says that it has to be voting, it has to be someone voting personally only. Can I clarify why that is worded this way? Thank you. Well, I can see that in Chinese text it says not an appointment of proxy. But let me be clear here. Power of attorney can attend the meeting on behalf of the owner. I think it is, again, the discrepancy between the Chinese and English text that is causing a misunderstanding here. Chair, let me supplement some information. When we're talking about appointing a proxy in the Chinese text, it would refer only to proxies. Regarding what Mr. Andrew Lam said about power of attorney, I do understand what Mr. Lam said, but we do want owners to attend the meetings personally, so it would be best not to have a power of attorney present. Let me declare an interest here. I am taking care of multiple elderly persons, so I would attend meetings on their behalf with powers of attorney. So if there are people who cannot attend due to difficulties in attending, for example, difficulties in mobility, then that would be a different issue. You have the concept of proxies, but power of attorney is most definitely different, and it is supposed to be allowed, but apparently it seems that you may not allow powers of attorney to attend on behalf of owners. Mr. Lee, I do understand Mr. Lam's concerns. We will review that after the meetings. Thank you. Mr. Ring Kong, I would like to follow up on the good questions asked by Mr. Andrew Lam. We have different types of instruments that would empower authorized persons to attend on behalf of individuals. And when you said at a meeting here, do you mean at a general meeting? Here, you only say at a meeting. So can I say that it would be any meetings? If it is an important issue such as maintenance, it should always be a general meeting. So can't you be more specific about that? And I can see that in English, at the very last part, it would say in order that a decision may be made by the resolution. I think this is unnecessary. Why can't you just end the sentence at the meeting? My third question relates to the discrepancy between the Chinese and English text. I think there is a redundancy in the Chinese text, or the English text rather, regarding a resolution passing, and a decision may be made by the resolution. So that would mean a decision has yet to be made. Why would you need to include that part in the English text? Chair. Thank you, members, for their very detailed questions. Regarding the first question, as other members have rightly pointed out, definitions are provided to be references in subsequent provisions to know what the meaning of the terms are. So the definitions are relatively simple here. It would only say for this definition in particular what the voting in person threshold would mean. And it is the case that subsequent provisions can make use of this definition without specifying all the details under this definition. And with reference to your question about whether we should use the term at a general meeting instead, I would say at a meeting, this wording is the general practice. Regarding the question about why the wording in order that a decision may be made by the resolution should be used. As said here, we need a minimum number of the owners, but if we only end here, we wouldn't be able to say what the implication is, why the minimum of owners would be necessary. So I think with the very last part, it presents the whole picture and it reflects the accurate intent of the law. Thirdly, in order that a decision may be made, it refers to, as I said earlier, there should be a minimum number of the owners that have cast a vote when making such decisions. So this would be consistent with the policy intent.
Mr. Rincon, what about the question about meeting? Do you mean general meeting? When this word appears in subsequent provisions, it explains what it means. In the subsequent provisions, meeting also refers to general meeting. So why don't you set it down more clearly? It's about the position of legislation. When one can understand the meaning by way of logic, that's the way we draft the law. We need to be succinct. Otherwise, legislation will be verbose. That's our choice of words, and that's a criterion. But Mr. Rincon's approach is not wrong either. It also works. But we actually focus on simplicity. Mr. Lai, the word proxy, I'm not sure you will further clarify the meaning of the word proxy. I suggest you should go back and think over. If need be, you should write it down more clearly. Apart from physical meetings, on many occasions, there are Zoom meetings as well. When you convene Zoom meetings, how can one vote in person? There are problems. Some meetings are conducted in a mixed manner. When you are free to come, you can come to the meeting. But if you are not free, you can also stay home. Just like an elderly person who is not fit to move around, he or she can authorize a grandchild to attend the meeting by way of Zoom. So how do you define voting in person? There are advanced technologies, and you can rule out the possibility that some may attend meetings both physically and by way of Zoom. Many organizations are using this approach. So what is the definition of voting in person? This will give rise to a lot of problems. In a meeting, when one votes in person, one needs to attend the meeting physically. For example, I've come to the meeting, I support all 5 items, and I pass the piece of paper to the person next to me. Just pop it in. That would be the ordinary approach. However, when one attends the meeting on Zoom, the person is not at the scene. The person only attends the meeting on Zoom, online. That is different. Undersecretary, thank you, Chairman. Thank you, Mr. Lai. As I understand, the Secretary also responded to similar questions. Under Cap 344, at this stage, one needs to attend the meeting in person and vote in person. That is the existing requirement. But of course, we won't rule out the possibility of technological advancements in the future. We can handle that after technological advancements take place. But today, we are talking about attending a meeting in person and voting in person. Now that it's the current policy, so I hope that when you issue guidelines or any other papers, please be clear. There will be record of the meeting today. At least members understand the original intent of the policy The way it is written right now only refers to physical meetings, attending meetings in person. So in case of disputes, we can refer to the minutes of this meeting. But it'd be better for you to set out clearly in future instructions or papers that can prevent any unnecessary disputes, since these can lead to legal proceedings, and that would be really necessary. All we do is to set down rules, regulations, so that there are rules to go by. The meeting today is scheduled to end at 10:30. 3 more members would like to speak. After these 3 members speak, the clause-by-clause examination of the bill will be adjourned until the next meeting. If we will overrun, I will extend the meeting by 15 minutes tops. Professor Priscilla Lam. Thank you, Chairman. I'd also like to follow up on POA, power of attorney, to attend the meeting and proxy. I'd like to follow up on these issues. I have similar experience as well. A company can authorize a representative. For example, in this case, you can authorize a natural person, that is, an authorized natural person. In my experience, if a natural person is the owner of the relevant flat, when he or she goes to meeting, he or she can ask a family member living together to attend a meeting. It's common for companies to send an authorized natural person to attend a meeting. I'm not sure about this. This is an amendment, so you added the word or the phrase an authorized natural person. Are you referring to the power of attorney? Otherwise, in the definition of voting in person threshold, you also mention proxy. That is, who must have cast a vote on a relevant proposed resolution personally, but not by proxy. It's more convenient for companies to do so, but then for natural person in possession of a property, that'd be much more inconvenient. One needs to pay in order to get things done. Is there no room for considering allowing such room? What about properties possessed by natural persons? Can a vote only be cast by proxy? Flat owners will definitely ask for proxy, whereas for companies there are authorized persons, and that is much more straightforward. Undersecretary, based on what Professor Leung said, a body corporate, that is a company. Earlier on, we also touched upon the definition of a body corporate. An authorized natural person is the persons authorized by a company in possession of a property. I'd like to ask the Deputy Director to give you more information. Mr. T, existing legislation does not have voting in person threshold. So, for a company, when you use a proxy, you will be considered as having cast a vote. Natural person can, of course, vote in person or vote by asking a proxy to cast a vote. There are no restrictions. In the existing legislation, there is no voting in person threshold, so there are no different definitions. We propose adding this definition in order to help company owners. Otherwise, companies would not be able to attend in person. This will be against our policy goal. So we do want to allow natural persons to attend the meeting, and we also want to allow owners of body corporates to attend so that they can be considered meeting the voting in person threshold. Well, you have already pressed the button to speak in the second round. Well, the administration hasn't answered my question. If you have already pressed the button, I'll allow you to speak in a moment. Thank you, Chairman. Next, Mr. Paul Tay. Let's talk about the difference between power of attorney and proxy. Legally, a power of attorney, according to Section 7, a mortgagee can also act as a natural person or a power of attorney. It's not the proxy as we commonly understand, like authorizing any person to act on your behalf. That is not the case. Well, I think the DOJ understands what I mean. Just now, the DOJ explained in answering Mr. Rincong's question, it sounds reasonable, but when I read the drafting done by you, it seems self-contradictory. For an authorized person under company or organization, the phrase general meeting was mentioned instead of a meeting. In the last paragraph, you don't need such details. So when you compare the definitions, one is the explanation given by the DOJ, whereas the other one is not. It's not wrong per se, but stylistically or for ease of understanding, can we aim at consistency? It would be better, and it would allow members of the public to understand the matter more easily. I'd like to ask the director to respond. Thank you, Chairman. Let me give you more information about the context of proxy and authorized natural person. Before the amendment in the existing legislation, there are no such requirement of voting in person. So whether the owner is a natural person or a company, of course, the natural person can vote in person, or one can also assign a proxy and ask a proxy to cast a vote. For a company, the company will send a staff member or any person to vote in person. There's no need to engage a power of attorney, as that person itself is a proxy. In the amendment bill, in the context of large-scale maintenance, a certain percentage of flat owners need to cast their vote in person. That is why we rationalize these terms. When we require them to vote in person, we need to set out more clearly the threshold. In the case of a company, we also need to set out clearly the threshold. A company cannot attend the meeting per se and cast a vote. So we have already proposed adding the phrase authorized natural person. Right now, simply put, we can use proxy. you have told us what we all know, but you did not focus on my question. If it's POA, why can the POA assign or authorize a proxy in the transaction of properties?
主席，我諗
That's correct, Chair. The power of attorney can vote, but we will not include them in the calculation of voting in person threshold. But why? Because power of attorney can act on the behalf of an individual in property transactions or when applying for a mortgage. It doesn't make sense why they can't vote on behalf of the individual. Thank you. Undersecretary, I had answered a question raised by Mr. Kong in this area before, and we have communicated to members our policy intent. We do note some deficiencies. We will consider that in future. Chair, I do understand we have time constraints, but I would like to say that casting a vote is an official process, and when we say cast a vote, it would include one putting the vote into a box. In elections, that procedures are set out, so things are very clear cut. But with meetings of owners corporations, the voting process is very chaotic. Not every corporation or management company would have a box for owners to cast votes. So I think we have to take into consideration we have different processes. Even for abuse committees these days, we do not have very standardized minutes. So I think you should be clear in your definition what the voting process would include and what cast a vote actually means. Thank you, Undersecretary. Thank you. I think we have already answered the point when answering Mr. Yang's questions. Thank you. Mr. Kong. We are currently thinking about formulating legislative proposals in relation enduring power of attorney. For example, if I think when someone is allowed to attend on behalf of an individual, if one has signed an enduring power of attorney, when I become mentally incapacitated, can this be changed? And they may not be able to revoke their power of attorney should they wish to make a decision other than that to be made by the power of attorney. Let me clarify something here. Proxies can still vote, but for the calculation of voting in person threshold, whether there are 5% of the owners or 100 owners who have voted, this would become a consideration. So we are not saying that proxies cannot vote or express their views. I believe Mr. Andrew Lam talked about power of attorney, and as said by Mr. Paul there earlier, is it the case that when power of attorney casts a vote, whether it should be counted when calculating the voting in person threshold? As I said earlier, we'll take that into consideration. But for proxies, we're just saying that it's not that proxies cannot vote. It's just that it will not be included in the calculation of voting in person threshold. Professor Priscilla Leung. Thank you, Chair. I'm just saying for authorized natural person, you can perhaps include this and have individuals who are acting on behalf of other people by powers of attorney. And that would resolve all the problems. You said earlier that it would not include POA in the voting in person threshold, so would you consider including that in the definition of authorized natural person? I do understand what members said, and we have set the threshold, as I said earlier, for 5% of the owners or 100 owners to participate in the decision for building maintenance. This is to enhance fairness and transparency. So we, of course, cannot include proxies and treat them the same as owners. So we're just saying that it's not that one cannot vote by proxy, but we should have a voting in person threshold for owners specifically to enhance participation of owners. Professor Priscilla Leung, I do understand the intent is to tackle rigging and domination of certain owners. I would say that for those who are authorized, they would also have to attend meetings. You should allow these people who are acting on behalf of owners, because they have fulfilled a responsibility to act on behalf of owners. You just want to prevent the situation in which one owner can vote for, say, 50 owners. So if we have someone who is familiar with the situation but is acting on behalf of another person, we should allow this. All right, I do note your views. I'll let Mr. Andrew Lam ask his questions and our meeting will end. Mr. Andrew Lam, please. I believe the microphone was not turned on. I do hear what the Undersecretary said. I just want to ask about for enduring power of attorney and estate. In these situations, the financial matters would be dealt with by a power of attorney. So I want to know at the next meeting whether power of attorney is included in the arrangement, and if not, what is going to happen with powers of attorney. Thank you. Thank you. This is the end of the discussion of this item. Agenda item number 2, any other business? There is no other business. If members have no business, I will just tell members that the next meeting is to be held on 12th of March, Tuesday, between 4:30 and 6:30 p.m. Please be punctual when attending the next meeting. Meeting adjourned. Thank you.